Hello, my name is Captain Singh and we are 5 members in our group. We are going to present a case between the Sanctuary Lakes and the Taxation Commissioner 2013. The report intends to highlight the case relating Sanctuary Lakes Private Limited to avail deduction from the taxation not have been availed by the company. And my friend Narinder will explain the case issues, and Kulvinder will be explain rule of this case, and Saranjot will discuss about applications. Now my friend Narinder is going to explain the issues.
Hello everyone. Here are some issues related to this case. In the current scenario, it was found that Sanctuary Lake Private Limited initiated that process of developing the Sanctuary Lake Resort in Victoria. Now I will discuss about the issues related to this case. So first of all, there are some issues related to Sanctuary Lake Private Limited, that process of developing the Sanctuary Lake at the Victoria point. Moreover, the provision of the facility of a golf course, and the other one is company did not go well and have suffered losses as lesser number of memberships were avoided for the golf club. So there are some other issues that the Commissioner of Tax assessed the return filed by the company and prohibited the level of deduction to the organization as claimed. The another one is, as the claim were made wrongfully, the Commissioner levied a penalty of 25% upon Sanctuary Private Limited. Now my friend Kulvinder will discuss some of the rules about this case. Thank you.
Hello friends, as my friend Narinder Singh fully explained the introduction about this assignment, now I am going to explain the rule of this assignment. The first one is a Sanctuary Lake Ltd violated the provision of section 8(1) of the income tax assessment. It's violated by the this company, and the Sanctuary claims deduction against which it did not have any explanation fully. It does mean it does not explain fully explanation related to the law. And Sanctuary Lakes made a claim for the deduction from the taxable income of the company for the loss by the organization. And the third one is that the consideration provision of section 8(1) of the Income Tax Assessment Act 1997, deduction which are revenue in a nature are allowed by the Act, while the provision prohibit allows deduction which are capital in nature under the 2011. And apart from that, AAT upheld the argument of the Commissioner of the Taxable and rejected the claim made by the Sanctuary Lake PVT Ltd, which are in the violation of the provision of section 8(1) income tax assessment. The Commissioner a penalty of 25% up on the company for its failure to apply appropriate care. And according to the provision of section 298 of the Schedule of 1 Administration Act 1953, the Commissioner also supported his argument with the decision made in the case of 2012-205 FCR 136, and the AAT, the federal court, rejected the appeal made by the Commissioner of Taxation asset penalty imposed upon the Sanctuary Lakes PBT light of the provision of section 298 Schedule 1 of the Taxation Administration Act 1953. Now my friend Shanjot will explain the applications.
Hello friends, my name is Sharanjot Singh and I'm going to explain the application regarding this case. And under the applications, breach of such provisions has taken place in the case of Sanctuary Private Limited. As Commissioner of Taxation, it was the duty of ATO to provide the adequate reasons and grounds of Sanctuary Lakes Private Limited for dismissing the deductions claimed by the organization. It was also the duty of the company to consider the fact relating to application of appropriate care while preparing the annual returns and making the claims for such deductions. It was the duty of Commissioner to apply appropriate logic and to conduct the further assessment of the provisions of Section 298(20) of the Taxation Administration Act 1953 before levying penalty of 25% upon the organization. And now we can under the application, it was the duty of Century Lakes Private Limited to consider in nature of deduction as per the provision of Section 8(1) of Income Tax Assessment Act 1997. And AAT upheld the decision of Commissioner of Taxation in regard to the violation of the provision of Section 8(1) of the Income Tax Assessment Act 1997. Both the federal court as well as the AAT should have conducted an assessment of scenario in the light of the provisions of Section 298(20) of Schedule 1 of the Taxation Act 1953. And now we conclude, my friend will conclude regarding this case, Century Private Limited as Commissioner of Taxation 2030. So my friend will be the concluding this case.
Under the conclusion provision of Section 8(1) of the Act, specially state claims can be made for the deductions which are purely revenue in nature, and no claims will be entertained for deductions which of the capital in nature. And that's all for the presentation. Thank you.